Good afternoon. It's August 5th, 2020. It's the Economic Justice Law Review Weekly Scholarship Digest. I'm your host, Andre L. Smith, DreSmith, SmittyBanton. You know me, professor for 14 years, former professor for 14 years at American Association of Law School Institutions, Howard University School of Law, Penn State University Dickinson, Widener, Delaware, and also Florida International University. So, as you know, every week we present at least three pieces of scholarship that can be characterized in terms of race economics in the law, or more specifically in terms of racially asymmetric market imperfections, right? Uh, Racially asymmetric market failures and imperfections. So criminal justice, we will often represent as racist criminal justice, we will often reference as racially asymmetric transaction costs. Let me find my little externalities. I'm sorry, right? Or the school to prison pipeline. We would recharacterize that economically as racially asymmetric market information, available to Black people. When we talk about media stereotyping, we're often talking about, we can recategorize that as racially asymmetric market information about Black people. Racially asymmetric market competition, we're often talking about the racial wealth gap. We're talking about employment discrimination. We're talking about discrimination in contracting, like the Byron Allen case. And of course, there is racially asymmetric profit maximization or market engagement. In other words, hate crimes, microaggressions. Those are things that drive Black folks crazy. So on the one hand, produces sort of an irrationality, or at least market irrationality, or maybe even more specifically, a market withdrawal, where Black folks don't even want to deal with either the market or this country entirely, right? So racially asymmetric market failures and imperfections in terms of profit maximization, market competition, market information, and then also transaction costs and societal externalities. So every week we find newly published scholarship that reflects that we can recategorize in these terms. We're going to do this in a more truncated fashion than we ordinarily have done, because I am finishing up, or trying to finish, a book called Afro-Atlantic Jurisprudence, where I get to describe these things in much greater detail. Only way I can finish the book is if I kind of pull back on some of these other projects that I'm doing. So unfortunately, we have not had this weekly digest the last 2 weeks, but I just can't not give it to you. So we'll just have to do a truncated version. So we're just going to hit straight right to it. Talk about this week's scholarship, the papers that have come out this week that deal with race economics in the law, or at least race in the law, and we can recharacterize it economically. The first paper is Kathleen Kim out of Loyola Marymount, the 13th Amendment and Human Trafficking, Lessons and Limitations. 36th volume of the Georgia State Law Review, page 105. And it's dealing with, again, we're talking about human trafficking, we're dealing with slavery. The legislation that she discussed is based off of the 13th, emanates or is authorized by the 13th Amendment. However, she is very careful to point to what the limitations of the statute in relation to the amendment are, because she is concerned about over-criminalization and how that affects people of color. So on the one hand, human trafficking, we want our girls, we want our women to matter, right? We want that to protect them. And so legislation such as far as anti-trafficking is obviously important. On the other hand, Kathleen Kim also takes seriously over policing, disproportionate as exploring the limitations also of the 13th Amendment. So that is our first paper, the 13th Amendment in Human Trafficking by Kathleen Kim. The second paper we're going to talk about today is Kara Swanson's. And this is a very good paper. I actually, I wanted to give you just an abbreviated version, but I had to watch pretty much, I had to read the whole thing. I know it's keeping me from finishing my book, but I'm sorry, I just got to keep abreast of the things that we're doing here. So, and you notice that I got new technology, so now I can see what's going on. Shout out to Rhonda Ryan, Central High School 248 in the building. So all this new technology I'm trying to get used to and bring us into the 21st century. All right, the second paper is Kara Swanson's, again, Race and Selective Legal Memory, Reflections on Invention of a Slave. The 120th volume of the Columbia University Law Review, page 1077, 2020. This was a really interesting paper. I really should do even more on it. When he's talking about the invention of a slave, I honestly thought it was talking about conceptually, metaphysically, what is a slave? But no, it's actually very practical. She's talking about whether a slave who invents an item can receive a patent on that item. So the answer was no in 1858. There was a case of a slave named Ned that was owned by an Oscar or held captive by a slaver named Oscar. Oscar sent in the application, and different from other slave owners who just submitted their slaves' inventions in their own in the slave master's name. This guy actually put the slave's name on the invention, but still argued that it should be his patent. Right? That's actually how things work today. If you're an employee of a company, the company that you work for is entitled to the copyright or the patent over anything you produce unless you can show that it was totally distinct from your profession. So anyway, that was an issue back in the day. That hadn't been settled, right? And so the patent office held that a slave, being under the Dred Scott case at the time, did not have the legal personhood to actually be able to receive a patent. Interesting thing is, he also said the slave owner could not patent the invention either because he was not the inventor, right? Which is distinct from how we're doing it now, right? That if I own the company and you work for me, it is presumed as a work for hire that whatever you produce belongs to me, right? So it's interesting that we show this movement in the law where a slave owner had less rights over the enslaved person than some corporations and companies today have over their employees. And so I think this really confounds, if you really want to look metaphysically at the definition of slave, peon, serf, employee, the distinctions between each of them is more subtle than is popularly imagined. Again, in the law, an employee in the law in the 21st century right now is still a master-servant relationship, right? Oh, interesting paper by Kara Swanson. She's out of Northeast, Race and Selective Legal Memory, Reflections on Invention of a Slave. Oh, I'm sorry. I want to finish talking about her paper because she talks about that case, but the bulk of her paper is actually how it was one of the most popular cases for Black scholars to talk about, from W.E.B. Du Bois to a brother named Harry Edwin Baker, to a sister named Soulsby. I don't remember her first name, but this was a very important case for 100 years because it was used for and against the idea of, or the myth of Black inferiority. Black folks used that case to show that Black people invented things and were that were patent worthy, because white folks used to use the trope that Black people not being inventors is why Black people should not have the right to vote, why they should not be citizens, right? That the ability to patent an invention was almost tantamount to utility within this country, right? So remember that copyright and patent is one of the only affirmative rights in the United States Constitution. The United States Constitution talks almost exclusively about what the government will not do, right? How it will not treat its citizens unjustly, where in one of the only places where it tells the government that you must do this for the people is when it talks about copyrights and patents and protecting authors and inventors for limited times. All right, the third paper that we discovered this week that dealing with race in the law, and we can recharacterize it in economic terms, is Benjamin A. Levin's What's Wrong with Police Unions, all right? Very timely. He is a professor at the University of Colorado. This was published in the 120th volume of the Columbia University Law Review, page 1333. And so I will just recharacterize it in economic terms as such, saying that unions protecting white privileges represent herrenvolk socialism, right? And I think this is really timely because when we're talking about racial capitalism, we also have to recognize herrenvolk socialism. White supremacy will take both sides of the issue. So it doesn't, in my view, it doesn't relegate itself strictly to capitalism. It doesn't relegate itself strictly to socialism. So when we talk about unionization, the exclusion of black people from some unions is an example of herrenvolk socialism. But here we have sort of an indirect implication, right? Unions protecting white privileges represent socialism economically as racially asymmetric market competition in furtherance of racially asymmetric transaction costs in terms of the disproportionate penalties relating to crime and other forms of police conduct, right? So police brutality, disproportionate sentencing, all aspects of racialized law enforcement can be described in terms of transaction costs or racially asymmetric transaction costs. But it also shows how one type of market imperfection bleeds over or compounds another, because some of the penalties like driver's license suspension, yes, it is a extra transaction cost, but it is also one that hampers or makes the labor market, and therefore also represents racially asymmetric market competition to the extent those penalties are doled out disproportionately to black folks. So Kathleen Kim, the 13th Amendment to Human Trafficking, Kara Swanson, Race and Selective Legal Memory, and then Benjamin A. Levin, What's Wrong with Police Unions. And then we're going to finish today with Jeffrey Fagan and Alexis Campbell, both professors at Columbia, who wrote Race and Reasonableness in Police Killings. So we just talked about racialized law enforcement as racially asymmetric transaction costs and societal externalities, right? Their paper was published in the 100th volume of the Boston University Law Review, page 951. And for this paper is so dope, I gotta read a significant portion from it because it's just so good. Police officers in the United States have killed over 1,000 civilians each year since 2013. 1,000. The constitutional landscape that regulates these encounters defaults to the judgments of the reasonable police officer at the time of a civilian encounter based on the officer's assessment of whether threats to their safety or the safety of others requires deadly force. As many of these killings have begun to occur under similar circumstances, scholars have renewed a contentious debate on whether police disproportionately use deadly force against African Americans and other non-white citizens, and whether such killings reflect racial bias, right? We got to crunch the numbers. I know some of you are watching this are like, duh, but we got to have the facts. We got to have the numbers. We analyzed data on 3,933 killings to examine this interaction of race and reasonableness. First, we described the objective circumstances and interactions of police killings and map those events event characteristics to the elements of reasonableness articulated in case law. Second, we assess whether inherently vague constitutional regulation of lethal force is applied differently by officers depending on the civilian's race, giving rise to a disproportionate rate of deaths among racial and ethnic minority groups. We then assess the prospects for remediation of racialized police killings by testing the effects of an existing evidence-based training curricula designed to reduce police use of deadly force towards persons experiencing mental illness. This is very important, right? Especially to empirically evaluate the remedies. Okay, and then we're going to finish it off. We find that across several circumstances of police killings and their objective reasonableness, black suspects are more than twice as likely to be killed by police than are persons of other racial or ethnic groups, even when there are no obvious circumstances during the encounter that would make the use of deadly force reasonable. Police killings of Latino civilians are higher compared to whites and other racial or ethnic groups in some but not all circumstances. We find no evidence that enhanced police training focused on mental health crisis can reduce the incidence of fatal police shootings of persons in mental health crises or racial and ethnic disparities generally in police killings. Our findings suggest that the standards in constitutional case law fail to anticipate the circumstances of fatal police shootings and are therefore seemingly irrelevant in preventing racial disparities in fatal police shootings. In light of this constitutional landscape, we argue that the ineffectiveness of enhanced police training to reduce shootings overall and racial disparity within these shootings may reflect the absence of race-specific components in their curriculum. We suggest that the addition of training components that specifically address the role of race in officers' perceptions of risk and their decision-making in potentially dangerous interactions with citizens may remediate both the incidence of police shootings and their apparent racial and ethnic disparity. All right, that's Jeffrey Fagan and Alexis Campbell out of Columbia talking about race and reasonableness in police killings. It can be found in the Boston University Law Review. It is dealing with racially asymmetric transaction costs and societal externalities, right? And again, I promise that we're going to keep these things short week to week, at least while I'm trying to finish my book, Afro-Atlantic and Jurisprudence. I'll check for it when it comes out. Until then, we'll be back next week. Economic Justice Law Review, Weekly Digest Review. I'm your host, Andre Smith. See you next week.